So if I'm a clinician approached by a patient asking about an assisted death, what should I do with that information?
Okay, so obviously in receipt of this information, you're bound to have some ethical concerns, some moral concerns. You're going to be worried about the patient. But the most important thing to remember is to apply the usual legal principles you do every day. So for example, confidentiality and data protection, and also the usual professional standards you apply every day as well, such as good medical practice by GMC, and that'll give you a good framework to work through how you're going to assess this information and what to do next.
Okay, so with those resources, where should I start?
Well, the first thing is, as set out in those standards, to make your patient your first concern and your priority, and respect their dignity, their autonomy, and their confidentiality. So if they've made you aware that they are thinking of looking into assisted dying, most likely abroad, then your starting presumption is always going to be that that's information you're going to treat confidentially and in line with the patient's wishes.
Okay, and what should I think about next then?
Well, one of the first things that you'll want to think about is whether the information you've received suggests that a criminal offence might have been committed or might be about to be committed. So obviously, as a clinician, it's not your job to investigate crime. You're there to care for your patient. But you will want to think about whether someone is assisting or encouraging this person with suicide, because even if they're travelling abroad, that is still a criminal offence in UK law. It's not to say you're going to run off and inform the police immediately or try and prevent this happening. That's something you need to work through bit by bit. But it's definitely a bit of information just to ascertain at the beginning from what you've got. You know, if you're not sure about that question, don't worry about it. You can move on, but it's always worth just thinking that through.
Okay, and is there anything else that I should be thinking about?
Yeah, so the next thing right at the beginning will always be to think about whether this patient has mental capacity to take these decisions we're involved with here. So thinking specifically about whether they are planning to undergo assisted dying, you'd want to think about the mental capacity to do that, but also thinking about the mental capacity to take decisions about what you do with the information they've provided with you. So again, the usual principles apply. We need to presume people aged 16 or over have mental capacity, and that includes to make decisions which others might think unwise, which could apply to assisted dying, of course. And we can't assume they lack capacity just because of their age or their disability or their health condition or maybe some mental health history that we're aware of. We'd actually have to be satisfied applying the usual principles that they're unable to take that decision due to a mental disturbance or impairment. And you approach that question in the same way as you do day to day as a clinician.
Okay, so it's thinking about it in the context of safeguarding as a safeguarding issue as well.
Yes, exactly. So if this person is looking into assisted suicide and really you're concerned they don't have the capacity to be making those kind of decisions, then yes, it does become a safeguarding process, and that completely changes the way you'd be approaching the matter. But that's not the case if it's a competent individual.
Okay, so let's assume the patient does have capacity. What then?
So make the patient your first concern, and your presumption is going to be that they're going to be involved in any decisions about what happens to this information they've shared with you. So you may not need to do anything with the information. You'd have to think, is there actually a good reason why I feel I need to do something with this information? That could be it's something you want to pick up in the context of your ongoing care. It's relevant to the conversations and care you're having with your patient. Or you might feel there's a need to share this information with someone else that would be best for the patient. The key thing is, though, here, because it's a patient with capacity and your duties of confidentiality and putting them first, means that would be a conversation to have with the patient, and you should be explaining why you think the information might need to be shared or could be shared, providing your reasons for that, and then seeking their consent to doing so. That's the basis on which you'd need to approach it.
Okay, and if you do feel that information needs to be shared but they won't consent, what do you do then?
So yeah, if the patient refuses consent, or maybe you feel it's more pressing, there's no time, it's not possible, then you're left with your default starting position, really, which is that you're not going to share this information without their consent. You respect their confidentiality. Now, there are some other circumstances where you can share confidential information like this without someone's consent. So one could be where there's some legal obligation on you to do so. For example, there's a court order requiring you to do so, but that's unlikely to apply here. And equally, for a competent patient when no one else is at risk, you're unlikely to be in a situation whereby you have a duty to share information for safeguarding purposes or to protect anyone else. So what you're left with then is this exceptional basis for disclosing information, which is where it's justified in the public interest. Now, that's actually quite a high bar because it's not just about you having a good public interest reason for sharing the information. It has to override the very strong public interest in maintaining patients' confidentiality and respecting their wishes. So you would need to be weighing up the benefits you see in sharing the information, the risks if you don't do that, but also you need to think about the impact on the patient. You know, if you breach their trust and their wishes in that way, that could really harm your ongoing relationship. It could lead to them disengaging from care with you, but also other agencies and professionals they're dealing with, which could potentially put them at more harm. And you do also need to think about the overall public interest in, you know, the healthcare profession and the NHS, that people understand their information won't be shared without their consent. So generally speaking, that's going to be a very hard test to meet. If you've got a competent adult who wishes to travel abroad and has the capacity to do so, I can't really think of any circumstances where you would be entitled to share that information without their consent, unless there was some risk of harm to someone else.
Okay, can you give me an example of when disclosure might actually be justified then?
Yeah, these circumstances are going to be pretty limited, but someone who lacks capacity to take decisions of this nature, is in the process of trying to travel abroad or is already abroad, is obviously at risk of death or serious harm in these circumstances, and an intervention might be justified in terms of sharing information with people within the UK or even with the facility abroad to bring that to their attention. Obviously, in that case, that would be a safeguarding matter and it would be about looking after the best interests of the individual. So that could be justified in the public interest or on a best interests basis. But I do need to emphasise that wouldn't be the case for a competent patient.
Okay. And is there anything I need to think about if the disclosure comes from someone else, a relative or a care provider, for example?
Yeah, I think that can affect how you go about it, but it's still personal and sensitive information about the individual, so I would work through the same process even if it had come from someone else.
Okay, so what if I'm contacted by a assisted dying facility in another country? Am I allowed to share information with them?
Well, given everything we've discussed, you'd have to run through all of those same principles, and you would need to be somewhat wary of doing so, given the offence of assisting encouraging suicide. But of course, we're going to put the patient at the forefront, make them our first concern, and of course they have rights to access the information and they get to decide who that gets shared with. So I would just want to be sure that I'm speaking directly to the patient if I can, to confirm this is what they want, that they're seeking this information to be passed over, or I may even agree to provide it directly to them. But as with any institution just contacting you out of the blue for information, we shouldn't just hand that over without any checks. And that's actually particularly important because we've got to remember we're not actually engaged in the ongoing care of the patient here, where we would routinely share information with other healthcare providers. This is assisted dying, and I do think there is a boundary there that we would need consent to cross.
So you've talked a lot about professional standards and confidentiality. Is there any other legal considerations?
Yes, there are. The main one would be data protection law, of course, because we're dealing with someone's personal data here. But the reality is medical confidentiality and professional standards are going to be much more useful and are actually stricter in trying to get to the right answer. In most cases, you would be seeking explicit consent to sharing this information in these circumstances, and that would be satisfactory for data protection law. If you were making a public interest disclosure without consent, I'd definitely be recommending that you're seeking the input of your information governance team, your Caldecott guardian, and potentially legal advice if needed, and that would enable you to be confident that data protection considerations are considered as well.
So could all this change if the bill comes into force and assisted dying becomes legal in the UK?
Yes, it definitely could. So there's a bit of uncertainty at the moment because it's still a bill making its way through Parliament, but as it stands today in June 2025, it contains a lot of provisions about data sharing. So, for example, mandatory notifications to the new commissioner who would be established, gateways for lawfully sharing information between key bodies like the Care Quality Commission and the professional regulators, and also requirements on record keeping, as you would expect. But we will have to see what happens with that. But even if the bill does become law, while that is going to change things considerably from what we're discussing today, the usual principles around how you care and make patients your first priority will continue to apply.
Absolutely. It's been really helpful to talk through some of those issues today. So thank you.
Thank you.